I am going to go ahead and kick us off a little bit, kind of coming in for those who might be just catching up. So I apologize that we're coming in a little bit abruptly as we kind of transition into what might trigger an organizational investigation. Um, what are some of these key practices and um,
Yeah.
that and characteristics through the life, or I'm sorry, through an investigation and the objective of investigation, and how do you achieve these in practice?
Yeah, so for an organization, there are some specific triggers that could prompt an investigation. It could be, for instance, a subpoena or a regulatory inquiry from one of the federal agencies or a state agency. It could be a whistleblower complaint. Uh, Also, the result of an audit finding or some type of compliance program disclosure that was made. Media reports. If media is conducting their own investigatory journalism of a particular organization, that report could also trigger an internal investigation to determine what is happening, who's responsible for it. Also, the misconduct of a business partner. Those are some of the triggers of an investigation. And typically, what investigations involve, well, they could involve incidents of harassment, discrimination, retaliation, employee threats, violence, theft. And so it's rare for those types of investigations to be scrutinized publicly. But when an investigation deals with a corporate officer or a member of the board of directors dealing with a conflict of interest or embezzlement or some type of deceptive practice that could impact investors, those kinds of investigations are typically scrutinized not only by a regulatory agency, but also by the public and by the media.
That's really interesting. I never really considered the various ways that an investigation might be triggered and kind of get started.
Mhm.
Um,
And so an investigation is, well, it's expensive, right? It typically involves perhaps outside counsel fees, perhaps third-party consultants. Also, uh, it's a disruptive time for a business, okay?
mhm.
Assets, resources are taken away from the typical business process so that an investigation can be conducted. But it's important because the Department of Justice and the Securities and Exchange Commission, when there's misconduct that is to be found, if a corporation or an organization has conducted an investigation, and how the investigation was conducted, whether it was complete and fair, objective, and done in a timely way, then that becomes a credit or it becomes a factor for leniency if an organization is facing any type of fine or sanction by the government. And so
Interesting.
it becomes very important for an investigation to be conducted professionally. And
Hmm.
so what is happening, what we're finding now is that, and if you had slipped to perhaps slide 6,
Sure.
Kelly Force, what we're finding is that those investigations that are done in a way that, like on an ad hoc basis,
Hmm.
rather than being done by a professional who is certified, who has taken advanced graduate courses so that they're qualified to be an effective investigator. That's what companies are looking for now. Those companies that conduct an investigation ad hoc, saying, "Okay, this
Hmm.
person is in HR, and so we're going to let them do the investigation," and that person doesn't have any investigative skills. Well, that company conducts that investigation at their own peril, and there are a
Gotcha.
lot of risks. And perhaps maybe one of the best ways to determine what kind of risks there are is by looking backwards.
Hmm.
If the investigation ultimately is subject of litigation, like in a discrimination suit or a harassment suit. Uh, if it becomes subject of litigation, the kinds of questions that a regulatory agency or a judge or even a jury might ask would be, well, what was known? And when was it known? And how promptly was an investigation initiated? Was the investigation thorough? And importantly, were any wrongdoings identified and addressed appropriately and timely? So if those 5 questions are not answered
Mhm.
satisfactorily, then an investigation could really be a failure and hurt the reputation and the credibility of a company.
Yeah, I can appreciate why that's important. Yeah.
So I think then probably what we should do is take a look at some
Mhm.
of the pitfalls that
Sure.
an investigation could encounter. And these are foundational. And so let's take a look at one of the scenarios here. Let's assume that a company called Zenith Financial Group, a large multinational bank, had an internal alert that was raised about $500,000 worth of unusual transfers from corporate accounts. And the company's internal investigator, David Chim, noted that John Baxter, who is a junior accountant with a recent history of minor compliance infractions like late reporting,
Mhm.
had access to these accounts. And so David, he begins to focus solely on John. And David, who's the investigator, he doesn't do a forensic audit of the transaction logs. And so what happens is that he calls John in for a meeting, and the meeting becomes confrontational right away. David begins to imply that John is guilty, and he does so in a premature fashion because he doesn't have all of the facts. He overlooks the possibility, for instance, of external hacking or any type of involvement of other employees that could have
Hmm.
similar access to these corporate accounts. And so let's face it, investigators are under a time crunch, right? They need to
Hmm.
produce a result quickly and efficiently. If they don't take the time, however, to do a thorough investigation by looking at documents, gathering documents, whether they're electronic or paper, gathering emails, looking at all the facts before they make an accusation, then they do this at their own peril. It's truly a
Mhm.
pitfall. And so a hasty judgment could certainly lead to an employee being unjustly punished, maybe even suspended from work. This would have an impact upon the employee's career and also could lead to legal action against the
Mhm.
company for wrongful termination. And so the better practice would be to gather all of the relevant evidence and avoid bias, right?
Mhm.
Consider the facts and avoid implicit bias uh, based upon an individual's past conduct or character, and
Yeah.
conduct an objective and comprehensive investigation.
It's interesting when we think about investigations. It's a very, loaded word sometimes in employment. And so often when I talk about compliance, it's, compliance is a leadership principle. And so many of these little small missteps, right? There's uh opportunity to give a lot of grace for employment decisions, right? So often folks are understaffed and overworked, and people are so trying to get things done in a really quick manner. And none of these actions are necessarily malicious. So it's just trying to, people are trying to get work done in a very quick manner. And yet without putting into place a really strong compliance program, right? Making sure that people are putting in reports in a timely manner, making sure that people have the tools to create reporting efficiently, making sure that there isn't pressure to shy away from a full audit or rush through a full analysis and collect data. Any of those things, again, not at all maliciously intended, could lead to an outcome that might result in termination, wrongful termination, and potentially a lawsuit.
Right. And it's key, as you mentioned, Kelly, that the important part of an investigation is that fact-finding process, and to avoid any type of external influences that could impact on truly and objectively finding the facts. And in this case, bias or of and really a misjudgment, an
Right.
assumption.
Right. Right.
So should we take a look at the second
Sure.
scenario? And yeah, so in this case, a company, a tech firm uh, known as Innovatech Solutions, there were allegations of harassment made against a project manager. And Sarah Jennings, in this case, is our internal investigator. As she was feeling the pressure due to the high profile nature of the case, since it involved a well-known project manager. And so during an offsite lunch with her friend, Megan, Megan worked in a completely different department. Sarah began to talk about the case. She vented, and she inadvertently mentioned the accused's name, Mark Sullivan, who was a popular and influential senior executive. And Megan, she became shocked by this revelation, and she shared the information with her own team. And so within days, what occurred was that rumors spread about Mark, half-truths, water cooler speculations. They were circulated throughout the company. And so what developed then was a fairly toxic work environment, and also Mark's reputation was unfairly tarnished. And so these types of cases involving harassment, they have to be dealt in a highly sensitive manner. Uh, even a casual mention about the nature of the investigation or any details about the investigation, that information can quickly spread in an
Mhm.
organization. And so this could easily impact the investigation's integrity, and also lead to the victim and the witnesses beginning to feel unsafe. My information that I provided that I thought was confidential is now being talked about in the break room. How did that
Mhm.
happen? Right. And so
Right.
this begins to really have an impact on the objectivity and on the credibility of the investigation. And it could cause witnesses to refuse to cooperate in the future, and obviously hamper the investigation's progress. So the better practice here is to follow the rule of only those who need to know should know any information. And that
Yeah.
is a very select group of those people who need to know. And otherwise, no information about the existence of an investigation or the process of the investigation should be disclosed to anybody else. And one of the things too that could be used is that when witnesses are interviewed, witnesses can be asked to keep the information confidential, not to talk about it. Okay. And that could be a condition that could be suggested to witnesses when they're interviewed, to keep confidentiality.
Yeah, I think one of the important considerations here is that it is very, especially in our culture today, right? People very much want to feel like they have some ownership in the justice of, especially in harassment situations. And I don't actually have a lot of judgment about that, but um, when, let's assume in this case that the allegations were true, right? Let's assume that at the end of this investigation, perhaps this person, Mark Sullivan, may have been terminated, and rightfully so, for these allegations that ultimately potentially were true, right? If we assume that they were. Because of this breach, that could put the entire investigation in jeopardy. And now potentially the company is liable for defamation. And now this person parts ways with the company, also potentially with some money in their pocket from a defamation settlement. And not only did the potential victims in this organization not get their um, justice that might have been owed to them, but there might now be future victims that are subject to this behavior, right? So there's absolute ramifications here, right, for not maintaining confidentiality.
Absolutely, Kellyanne. As you mentioned, one of the things that we want to encourage in an organization is a speak up culture.
Absolutely.
When someone sees something being done wrongly, we want that person to speak up, to say something to their supervisor, to someone in authority. And if this breach of confidentiality occurs, it really undercuts that speak up culture that we're trying to create.
Yeah, great. All right.
We take a look at our third scenario on
Sounds
slide
great.
12. So here we have a situation involving a leading biotech company, Biogen, and they're faced with a severe breach involving the theft of groundbreaking genetic research data. Okay, so this can have a big impact financially on the company. And so Dr. Robert Anderson, he's the lead investigator, and he concentrates his investigation on the senior research team. And he overlooks, well, he ignores the roles of support staff and interns and those who are not in the leading positions, not in positions of leadership or management. And Emily Harris turns out a diligent intern. She noticed that Dr. Martin, mid-level researcher, accessing the database late at night under suspicious circumstances, but Emily is never interviewed and her observations remain unknown. And so Dr. Martin continued to access and transfer confidential data. And then once he learned about the investigation, he was able to erase traces, the digital traces, and mislead the entire investigation. And so our situation here is that what should be defined first is what is the scope of the investigation? What is the parameter of the investigation? And then from that scope that is given to us as investigators, what is the plan? We should sit down and think before we start gathering documents and speaking to people. What is our plan of investigation? How are we going to proceed? And what should be included in that plan as far as what documents that we want to obtain, electronic, paper, when do we want to obtain them? And then what is the order of witnesses that we want to interview? Do we want to go right away with those people that we think are suspects? Or do we want to, at the beginning, figure out, okay, let's talk about those folks who are in cybersecurity in our office and find out what they know. What's the digital imprint for information that may have been transferred. And so having a plan of investigation becomes extremely important so that witnesses are not overlooked.
Yeah, definitely important. Not only to have a plan, but also to understand that you might not understand the space entirely and appreciate that asking those folks who really understand the space might lead you to develop or change your plan.
That's right, especially when it deals with digital imprints.
Yeah.
Having the advice and guidance from the cybersecurity team is going to be extremely important.
Absolutely. All
Let's
right.
take a look at our fourth scenario. And, obviously this is a situation when investigators become overwrought, right? They become overworked. And so at this fashion company called Lux, allegations emerged about a sales team using unethical practices to inflate their sales figures. And Lisa Monroe, an HR manager, was assigned to investigate. She conducted 20 interviews with sales staff and clients, but her documentation of these interviews, well, at the end of the day, it seemed to be inconsistent, disorganized, and many interviews were just, hey, listen, I met with John Smith at 3:00 to discuss the investigation, and there was no written record or detailed record of what occurred. And so Greg Thompson was found out to be someone who was involved in this unethical practice to inflate sales figures. And he sued. He was eventually fired, and he sued Lux Fashion for wrongful termination. Now, no matter whether he was wrongfully terminated or not, at court, the investigation, the report of the investigation became up, was a question.
Mhm.
And here the company struggled to produce any type of comprehensive, organized evidence to support its decision to fire or let Greg Thompson go. And so here's a situation that is a pitfall. No matter how busy you are, you've got to record, and by recording, make a record of the interview, uh, a summary of the interview, what was discussed, what did the witness provide, what documents were shown to the witness, and what did the witness say about those documents. And all of this needs to be packaged in a way so that 6 months, a year from now, you can take a look and say, okay, this is what occurred during that interview, and this is what the witness said during that interview about these documents or about this event. So it becomes crucial.
Yeah, for sure. I mean, any sort of corporate records, employment records, interview, investigative records, super, super important. And having a policy, right? We talk about this a lot in compliance, having a policy for maintaining those records. When do we archive them? When do we destroy them? And making sure we're sticking to our policies.
Yes. And I know that you and I have laughed before about the chain of custody,
Oh,
but
yes.
but it's important to have that
Hmm.
chain of evidence as to
Yes.
how certain documents were obtained so that they can be shown to be authentic
Hmm.
and that they
Yes,
were not otherwise manipulated in some way.
for sure.
So very good. So let's talk about our fifth and last scenario. So this is a situation involving really postponing an investigation, hoping that the event will cure itself, will go away. And so 4 months ago, a procurement officer, Lisa Nguyen, noticed unusual patterns in the organization's procurement process, and a substantial number of contracts for medical equipment were consistently awarded to one specific company. This company, Health Equipment Incorporated, was owned by the brother of the chief financial officer, Michael Davis. So Lisa reported her observations and suspicions to her supervisor, Kevin Smith, mentioning that this appears to be a conflict of interest. Kevin was concerned about the accusations of, surrounding that it could involve a high-ranking executive like the chief financial officer, and that it would be a fairly serious allegation of unethical conduct. And so Kevin Smith chose to handle this matter discreetly, hoping to gather more information on the side before escalating it to a full-blown investigation. So Kevin's discreet inquiries didn't go far, and he delayed taking any formal action, hoping the situation, of course, would be resolved without creating a scandal and having any adverse publicity. And so in the meantime, CFO, he continued to give contracts to his brother's company, and the quality of the equipment began to suffer and raise concerns now among the medical staff who are using this exact equipment. And so this leads us to the situation that an investigation should be conducted timely.
Mhm.
Obviously, an organization does not want to air their dirty laundry, right? But in order for an organization to protect its reputation and to have the public and regulators to have faith and confidence that the organization is going to police itself,
Mhm.
having a timely investigation is crucial. And in this case, hoping that it would go away, hoping that the situation might resolve itself, it was all for naught. And of course, in this situation, more and more staff became aware of this conflict of interest, and it could affect the credibility of the organization, the trust that the staff has in the organization, the appearance to outsiders and way that the organization is running itself.
Yeah. Yeah, definitely important. Also, making sure that you've got evidence isn't destroyed or it's able to be found and not missing those sorts of things too.
Yeah. So as perhaps as a summary, I think we can see that misconduct does not happen in a vacuum. It results from sometimes a perfect storm of factors like of employee unawareness or ignorance or a failure to see the larger implications, even a lack of training and the lack of having procedures in place, a failure of internal controls. All of these contribute to misconduct. And the result of an investigation is really when the investigator becomes a strategic advisor for the company. That after conducting the investigation, finding these facts, determining the root cause of the event and the incident, the investigator can then give recommendations to the company as to how to fix and how to cure the
Hmm.
situation so that it doesn't occur in the beginning. I've got the summary there on that slide as to what we've just talked about, but let me just say this. Are there other pitfalls for an organizational investigator? Oh, you bet there are. Exceeding the scope of investigation by chasing rabbits. We don't want them to
Mm,
boil the ocean. Keeping the board of directors or those who have a need to know ill-informed, not keeping them informed so that they're able to exercise the proper
mhm,
oversight. Unintentionally covering up or mishandling or destroying evidence through lack of care, improper use of polygraphs or lie detectors, not adequately protecting the attorney-client privilege or the work product privilege that exists over attorney work product materials, and also not understanding when an investigation becomes so complex that it's outside of the internal investigator's wheelhouse and that they should seek outside
mm.
consultants and outside counsel. Maybe those topics we can talk about in a future day.
Yeah, absolutely. I love that. As a member of a board of directors of a different organization, we rely on our staff and outside counsel a lot to keep us informed and provide analyses, and both in the context of investigations and hopefully for things that will never get to an investigative standpoint, right? But yeah, it's a huge job. It's a really big job. Um, so thank you so much, Frank. I really, really appreciate you being here. Certainly wanted to open it up for questions. We've got several folks participating today. You're welcome to raise your hand if any of you are involved in investigations and have questions about how to conduct those. Um, you're welcome to put it in the chat or in the Q&A box. I know sometimes the things that come up for me as a board member are um, in the early part of when things are not to the place where they're being investigated yet. And I hope that they never get to those places, but asking all of those questions of our staff for have we looked here? Have we looked here? What sort of data gathering pieces do we need? So we do have one question, and the question is, what about union representatives and their role in the process?
Yeah.
Um,
Yes.
yeah,
And
do
so
you want to
I'm
speak
so
to that?
glad someone has brought up that question. So
Yeah.
the Weingarten rule,
Mhm.
you remember that from our labor
Oh,
law,
yes.
uh, that if a union exists in an organization and the employee who's under investigation asks for a union
Mhm.
representative to be present during the interview, and if it involves the terms or conditions of employment, then the union representative must be there during the interview. That is called the Weingarten rule. And so, yes,
Yes.
that's a very important rule that must be abided by whenever it is a union shop.
Yes. I think it's also important to remember that the role of the union representative in that investigation, you probably want to check with the counsel for the union to make sure that you, as the representative, are not answering on behalf of the employee, questions that the employee should be answering, right? Um, and that you're not answering on behalf of the union questions that might be outside the scope as your role as a representative. So the follow-up question is a good one here. Can the investigated person bring an attorney? And that is likely going to depend a lot on the framework for the questioning. So I think that I mean, I say this wearing my hat as an attorney. I would always ask to bring an attorney. Um, but that doesn't mean that you always need to or that you always will know that you're being investigated, right? So I think sometimes when um, people are asked questions, you don't know where those answers are going. Maybe it's a part of investigation, but you didn't realize that it was. Hopefully that's not the case because I think that you should probably know if you're being investigated about something. I think it's always fair to ask to bring an attorney, and I think it depends on what's being investigated. And I think it's always reasonable to ask more questions, you know, what is it that you want to talk about? Can you give me a list of questions beforehand? I mean, I think that those are reasonable employee rights. I mean, this is a very typical answer from an attorney, right? I think it depends a whole lot. So I don't
Yeah,
know if you have other things to offer, Frank.
yeah, you're absolutely right, Kelly. This is an area that's fraught with litigation too. And so sometimes what's occurring is that the investigator's outside counsel is a lawyer who's asking the questions. And
Hmm.
so the interviewee is thinking, okay, well, this person is a lawyer hired by the company to ask me questions. So they ought to know that what is proper and what is not proper and asking me questions. And that's not the case. As a matter of fact, that attorney must give what is called the upjohn warnings. And the upjohn warnings are as to advise the interviewee that I am not your lawyer. I am a lawyer for the corporation and only for the corporation. And I act in
Hmm.
that corporation's best interests and not in your best interests.
Hmm.
So to answer the question there that was put into the chat, should the interviewee ask for counsel to be present? It depends on how grave the situation is, but in an abundance of caution, my answer would be yes.
Yeah, two really, really great questions.
Mhm.
I think the challenge is also, right, if you're on the employer side, building a compliance program, what does that look like? If you are being an ethical employer, right, we're talking compliance with a conscience. How do you protect the business? How do you build a compliance program that protects the business and also has compassion and ethical behavior on behalf of your employees? I cannot, as a compliance professional for the business, provide my employees counsel. What I can tell them is, we're going to have a meeting, we're going to have some hard questions for you, and you should seriously consider about calling an attorney. That would be an ethical thing for me to do as an employee of the business. So I think that those are the hard questions. That's not a legal answer, that's an ethical answer. And those are the hard things, right?
Ag- Agreed. I think that that shows that the company is willing to step out of its role, just of its own self-serving interest, and really take a look at the interests of its
Hmm.
employees. And so I agree with you.
Yeah. And that's hard. It's really, really difficult to do that, especially when you might be getting pressure from other parts of your organization to not empower your employees to act in their own best interests. So,
Mhm.
certainly open for other questions. I will kind of highlight some other things coming up. Um, we are accepting applications for our fall start. I can't believe we are already in 2024 and we have a fall 2024 class starting, which is like mind blowing to me. So plenty of time to get applications in at this point. However, we do have scholarship money available. Those scholarship funds are a little bit of a first come, first serve. We look at a lot of different factors. And the priority deadline for scholarships is July 1st. So please work to get your application materials in before July 1st if you want to be considered for the scholarship funds. There's a scholarship statement on the application, so you don't need to fill out anything in addition. It's right there for you. Um, The application deadline itself is August 12th. That's a pretty hard deadline this year. We really need to make sure that we have time to get everybody's financial aid and everything, make sure all of our staff enjoys the rest of their summer vacation, and we get everybody ready for fall start. And our classes are starting September 3rd. Um, so if you have any questions about those deadlines, and any questions about the applications process, we have an unbelievable staff here. I am super, super fortunate to be working with amazing people. And we are all here to answer your questions. Um, and you are welcome to reach out to us. Again, our contact information is below. It's LawGrad Online. The other shorthand, if you'd rather not write that down, MLS at seattleu.edu will also get to us. And you're welcome to reach out via phone. Otherwise, oh, so we do have one other question. What circumstances should an internal investigator be mindful of regarding internal conflicts of interest? Ooh, really good question. During an investigation that may require an investigation to be sent to an outside investigator. That's a really good question. Do you want me to
It,
read it again for you?
no, it's a great
Okay.
question. And, it boils down to when should investigations be conducted by outside counsel. And in these circumstances, number one, if it is a very complex case involving enormous amounts of money across different divisions of a particular company, that's when outside counsel should be involved. If it involves high-level officers or directors, on the board, for instance, if it involves those high-level officers or members of the board of directors where there might be an issue of misconduct, that's when outside counsel also needs to be involved to conduct the investigation. And so, and what the Department of Justice and the SEC kind of look at is that in these types of complex investigations, when outside counsel is involved, it gives an air of independence and resourcefulness that outside counsel can bring to an investigation. And so, those are also some of the considerations as to when outside counsel should be involved.
Yeah, I think the only other thing I would point out, I haven't worked on really high profile investigations like that, but smaller internal stuff, if there's a personal relationship, and maybe it's not something that's big enough to bring in outside counsel, but if there's a personal relationship that might have an internal conflict, um, it's worth seeing to if it's a big enough organization, seeing if you can find somebody else to do that. I think that the perception of bias is a real problem. Even if you're truly being as objective as possible, the perception of bias is something you really want to avoid.
Absolutely. Well said, Kelly.
These are great questions. I really appreciate you all engaging so much. These are fantastic questions. So certainly keep them coming if you have them. Well, I hope that this has been helpful. I really appreciate y'all being so engaged. We've really appreciated chatting with you. Um, For those who are interested and kind of continuing to keep a pulse on the program, we have another, it's not in a webinar format, but we have another event coming up virtually on February 3rd. If you've been kind of tracking our program for a little bit, we do a capstone as a part of our program. And for the first time, we are going to be doing a capstone symposium on February 3rd at 9:30 Pacific, 12:30 Eastern. You should be getting an email in the next day or so about that if you haven't already. And if you don't and you're interested, please let me know. But we'll have several of our alums highlighting their capstone, and it will be Professor DiMarino and I facilitating a discussion. And I'm super excited because the capstone is a part of our program that we don't often get to highlight in this way. And we did a webinar about it a couple of months ago, but to be able to bring some of our alums back and highlight their really varied uh, subject matter and content formats that they've produced for their capstones is going to be really exciting. So I hope you're able to join us on February 3rd. And any other parting words, Frank?
I hope to see everybody there at the symposium. It's going to be a great event, and I look forward to our next webinar, hopefully on
Awesome.
organizational investigation sometime.
Sounds great. Thank you so much. I hope everybody has a really great day.
Take care.
All right, take care. Bye bye.